David, this one goes to you. We talked through a lot of these risk factors of purchasing distressed assets. Does making the purchase through a 363 sale in a bankruptcy remove the risk factors that we've discussed through, the bankruptcy code allowing for free and clear sale and things like that?
It certainly mitigates and sort of minimizes the risk, but as we talked about a few minutes ago, it doesn't eliminate it entirely. I think that the first key to managing the risk and minimizing them is to have as broad a notice process as possible, because if creditors are aware of the process and have an opportunity to participate, that makes it more difficult for them to come back at a later date and say, I didn't like the outcome, so I'm coming after the buyer. So the first thing you need to do is make sure from a process perspective you are providing as much notice as possible. The second part, I would say, is borrowing from a talk at the ABI meeting last weekend, was words matter. So what does your sale order say? What does your purchase agreement say? Making those contracts and orders as precise and expansive as possible to cover the risks that you're trying to manage and avoid. I think that through the magic of word processing and past experience, you're finding sale orders have very long provisions that list all kinds of different statutory sections that the buyer is not going to have exposure for, and you're asking the judge to sign that order. So you also want the judge to make findings about your good faith, about the process, about the notice, the quality of the notice, the sufficiency of the notice, and whatnot. So it's not enough just to buy through a 363 sale. And remember, 363 is a code section which sort of delineates different things that have to happen for the court to approve a sale. And Jonathan and I both mentioned the plan process. So you could have a sale through a plan. You could also have a reorganization where the equity in the reorganized entity goes to a buyer, and so the buyer is a plan sponsor. There are ways through the plan process to get broader injunctions and releases. Again, there are trade-offs there. One is the plan process often takes longer unless things are done prearranged, prepackaged, et cetera, which is its own animal. And then there are risks associated with that in terms of inviting more people to the table and having a longer drawn-out process with more parties in the negotiation. But you need to be focused on the process and your agreement and your order to make sure that they are as, again, precise and as expansive as possible to provide the broadest protection from future claims.